Hello, Pod A students. Today we're talking about the criminal justice system. These are the notes that go along with chapter 16 in your book. So when we're talking about the criminal justice system, we are essentially talking about due process. Due process is a constitutional protection. It's covered by the 5th and the 14th Amendment, and it basically states that the law and the procedures of law must be fair. So all citizens, even when they've been accused of a crime, need to be treated fairly. The overall criminal justice process can be complicated and time-consuming, so we're going to try to walk through it today step by step. So step one is a crime. A crime has to occur in order for an individual to go through the criminal justice system. The definition of crime is all about intent. So states and federal law categorize crimes based on the level of intent. So the definition of a crime is the intentional act that violates the law. There has to be intent, and there has to have been wrong done to another individual or to society. A behavior could only be labeled as a criminal act if it was committed with intent. So it has to be illegal, right? There has to be a law against that thing. There has to have been wrongdoing, and there needs to be intent. So if you think about on the news, if you've heard about crimes, 1st degree, 2nd degree, 3rd degree assault, that's all about intent. So 1st degree would carry the strongest amount of intent. It was mindful. There is evidence that the crime was planned in advance and carried out. And then as the numbers decrease, the intent decreases as well. So remember that all crimes, in order to be classified as a crime, there has to be wrongdoing and there has to be intent. So then we get into the categorization of crimes. There are different crimes. You are probably already familiar with this. We have misdemeanors and felonies. A misdemeanor is going to be less serious than a felony. Typical consequences or punishments are going to include fines, maybe short jail sentences, maybe even community service or probation. Felonies, on the other hand, are much more serious. Variety of different categories of felonies. This is going to result in consequences included a longer prison time or time in corrections. In some extreme circumstances in certain states, it may even include the death penalty. So the categories that are listed here. This is a graphic from your book, so you can find this on page 288 in your textbook, but it lists the different types of felonies by category and gives you some examples here. And typically the felonies that we are probably most familiar with or hear about most frequently are violent crimes, things that include murder, assault and battery, kidnapping, but property crimes, crimes against the public like peace and safety or pollution, crimes against government like treason, drug crimes, white-collar crimes, counterfeiting, blackmail, fraud, victimless crimes, and privacy or technology crimes would also all be classified as felonies. The circumstances of the crime and the extent to which the crime was carried out may also help determine whether it's classified as a misdemeanor or a felony. So again, I mentioned at the beginning of the presentation due process. Remember that due process is covered by the 5th and the 14th Amendments of the Constitution. It is the guarantee that the law itself and the application of the law is fair. So we look at two specific types of due process. We've got procedural and substantive due process. Procedural due process is just that. It's referring to the actual procedures of law, the how, if you will. Was there a search warrant granted before a search was conducted? Was the individual given their Miranda warning? Were they given that protection from self-incrimination? Were they given a fair trial? Were they provided with an adequate defense? Those are all procedures of law. Substantive, on the other hand, is the actual law itself and how it's written. Is the law fair? It cannot violate the way that the law is written, cannot violate constitutional rights or liberties. So if a law is keeping a certain group of people from being able to do something, or it's putting restrictions on personal freedoms, the law itself might be found to be a violation of substantive due process. And these would be interpretations that would be made by the court system. Remember, it's the court's jobs to interpret the law, and they would be looking at due process. So as far as juveniles are concerned, when we talk about juvenile crime, and we're talking about specifically due process, remember from our town hall walls in class, Juveniles have some different expectations of due process than adults do. Traditionally, due process rights were somewhat different. Juveniles were tried in special courts. Typically, their consequence was a reform school or rehabilitation facility rather than a correctional facility or a prison. What they found was that oftentimes, though, these juveniles there was a failure to grant them due process rights to these particular suspects. It might include, longer times in these reform schools than they would actually serve for the same crime in jail. And through different precedents, the Supreme Court has said that juveniles should receive many of the same due process rights as adults, including the right to be notified of the charges against them, the right to an attorney, the right to confront witnesses, and the right to remain silent, which has not always been a protection granted to juveniles. Today's juveniles are going to be able to access most, but not all, of the due process rights that are guaranteed to adults. Juries, for example, are not mandatory in a juvenile case. We've also seen an increase in states deciding to sort of get tough on juvenile crime. And as we discussed in class, we've seen a lot of juveniles accused of serious violent crimes being tried as adults. All right, moving on. In these steps of the criminal justice process, so we have a crime that's been committed. So that next step is going to be an investigation. Once the crime has taken place, an investigation of that crime scene has to take place. There's a gathering of evidence that has to be done by law enforcement, interviewing witnesses, the whole goal being to identify a likely suspect. Evidence has to be presented to the state or the government prosecutor, who then has to decide whether a suspect should be arrested and charged with the crime. So law enforcement's job is to collect evidence, get that witness testimony or interview, identify a suspect, and then the state has to decide, is there enough evidence to go forward with a formal charge and an arrest. As far as gathering evidence is concerned, there's a couple different things. So before the prosecutors can actually file that criminal charge, they have to make sure that they've got a viable case against this particular suspect. So they have to have a clear picture of what actually happened before, during, and after this crime. So the prosecutors are going to have to examine both direct and circumstantial evidence. So direct evidence is going to be information about a crime that establishes a fact. It's typically provided by a witness who saw the crime either in person or by video or recording. So then you have circumstantial evidence, which is information that can be inferred from other facts. So the example that your book gives is if a suspect's fingerprints are found on the steering wheel of a car, the police can then infer that that suspect was present in that car at some point. So you're placing that suspect in the vehicle because of the fingerprints that are there. The fingerprints thus become circumstantial evidence. However, if a neighbor actually saw the suspect in the car, that is direct evidence. So circumstantial is saying that that person's fingerprints are in the car, but it doesn't necessarily mean it because that person committed the crime, right? If it's your vehicle, it's pretty natural that your fingerprints are going to be in the car. A more direct piece of evidence is someone actually saw the person in the car, even more so if the timelines line up and things like that. So in order for law enforcement to gather that kind of evidence, there has to be a search that's done. Which leads us into a reminder of our Fourth Amendment. So remember, the Fourth Amendment prohibits unreasonable searches and seizures. So remember, we've got a couple of different things that have to happen here. We know that there has to be probable cause in order for a judge to grant law enforcement a search warrant. We've talked about in class lots of different exceptions to warrants. So here's just a reminder of those things here. Remember, when you're at the airport, no need for a warrant. Anybody could be searched at any time. We oftentimes put the security of the many, right, over our individual freedoms. So in that case, it's a security protocol. We are all safer as a collective group if they have the ability to search without having to get probable cause and a warrant. School searches, we know you need reasonable suspicion. Obviously, if you're giving consent to a search, you're waiving your right to the Fourth Amendment. They don't need a search warrant if you have given them consent. We've talked about if things are in plain view. We also talked about exigent circumstances. Remember a couple of those simulations that we had in class with our Supreme Court activity. If there's an emergency, if there is a threat of destruction of evidence, those void the need for a warrant as well. And then we've also talked about lots of examples with automobile searches. The ability to search is much greater in a vehicle than it is in your home. When you've taken that extra measure of security, you're inside your home, you've closed your shades, the police can't come knocking down your door. Once you're out in public roads, in a vehicle, a lot of your actions are more visible. It opens up the opportunity for more searches. Also, just a quick reminder of the exclusionary rule. Remember, any evidence that is gathered without a warrant, unless it meets one of these warrant exceptions, cannot be used in a trial. So just kind of a reminder of that part of the procedural due process here. So let's say that we have a hypothetical crime that has taken place. There's been an investigation. Law enforcement has gotten the appropriate search warrants. They've gathered direct and circumstantial evidence, which has been presented to the state prosecutor, and that prosecutor feels that there is enough evidence to have law enforcement feels that there's enough evidence to make an arrest, and then the prosecution is going to bring charges. So remember, when we get to the arrest, we have other rights and liberties that we need to be reminded of here. Part of those due process protections include the Miranda warning. So remember, that's a big part of the Fifth Amendment, is that protection from self-incrimination. The Supreme Court precedent that establishes this is a case called Miranda versus Arizona. So in that case, from 1966, the Supreme Court ruled that detained criminal suspects prior to police questioning must be informed of their constitutional right to an attorney and their protections against self-incrimination. Miranda, who was a suspect in this case, was convicted of both rape and kidnapping and sentenced to 20 to 30 years in prison. And he was not informed of those rights. So the Supreme Court case established that the police must observe these due process rights when taking suspects into custody, and therefore we have the Miranda warning that you see over here. All of you have watched enough movies and police dramas to know that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, one will be provided for you. They will also then ask for confirmation that you understand the rights that you have been read, in which you'll have to answer. And then with those rights in mind, do you wish to speak to them? And this would be without your lawyer present. So if you say, no, I prefer to have a lawyer present before I answer questions, that needs to be provided for you. So at this point, we have reached the end of part 1 of the criminal justice system. So you should move on to the next screencast video that is going to talk about pretrial activity and what happens in the courtroom.